Forget everything you thought you knew about gun permits. The Supreme Court didn't just change the rules, they obliterated the entire game. For 70 long years, anti-freedom bureaucrats built an empire based on denying your constitutional rights, hiding behind subjective may-issue permission slips. They forced millions of law-abiding Americans in places like California and New York to beg for the right to defend themselves. Approval rates below 1%? That wasn't bureaucracy. That was tyranny disguised as paperwork. Did you feel that frustration? That anger? That chilling realization that your safety depended on the whim of some unelected official? You paid hundreds, sometimes thousands, just for the privilege of being told no. But in June 2022, the hammer finally fell. New York State Rifle and Pistol Association versus Bruen wasn't just a case, it was a revolution. And now the Department of Justice itself is launching the first lawsuit in American history designed to protect gun owners from government abuse. This changes everything. Stay with me, because the evidence they tried to hide about what's happening in Los Angeles is the key to understanding the future of your Second Amendment rights across all 50 states. This is your Frontline report. The Bruen decision wasn't a polite suggestion. It was a scorched earth legal standard dropped directly onto the battlefield of gun rights. Justice Clarence Thomas, writing for the 6-3 majority, delivered a clear mandate. The Second Amendment is not a second-class right. Forget the old complicated tests lower courts use to uphold almost any gun restriction. Bruen introduced the text, history, and tradition test. What does that mean? It's brutally simple. Any modern gun law must be consistent with how firearms were regulated back when the Second Amendment was ratified, around 1791. If there's no equivalent law from that founding era, the modern law is presumed unconstitutional, gone, thrown out. And guess what the historical record shows? Virtually no discretionary may-issue permit systems existed back then. Americans could generally carry firearms openly without asking anyone for permission. Justice Kavanaugh even wrote separately to hammer this point home. While objective, non-discriminatory, shall-issue systems might pass the test, those subjective may-issue regimes, where bureaucrats played gatekeeper based on personal feelings or political connections, Bruen specifically targeted them for destruction. Within months, the dominoes fell. California, New York, New Jersey, Hawaii, Maryland, D.C., all forced to scrap their decades-old may-issue systems. Victory, right? Not so fast. Because changing the law on paper means nothing if the bureaucrats refuse to follow it. And that brings us to the constitutional crisis unfolding right now in Los Angeles County. The Los Angeles County Sheriff's Department wasn't just slow. They were running a constitutional denial factory. Faced with Bruen's mandate to issue permits, they didn't comply. They just switched tactics from outright denial to bureaucratic stalling, a slow-motion infringement designed to make you give up. The Department of Justice investigation uncovered shocking numbers. Out of 8,000 applications analyzed, how many did the sheriff approve? 2. Not 2,000. 2. That's an approval rate of 0.025%. Statistically identical to a complete ban. How did they do it? Delays were weaponized. Interview appointments scheduled 2 full years out, deliberately violating California's 90-day requirement. The average wait time just to start processing? Over 9 months. Applicants were told files were lost. Impossible documents were needed. Staff shortages made it impossible. All while the department happily collected $400 to $1,000 per application, generating millions in revenue for zero service. This wasn't incompetence. The DOJ alleges it was a pattern and practice of intentional deprivation. And here is the most outrageous part. The people being systematically denied their right to self-defense live in some of the highest crime areas in the entire country. We're talking homicide rates 4 times the national average. These aren't wealthy elites in gated communities. They are small business owners robbed at gunpoint, night shift workers, domestic violence victims with restraining orders. The DOJ complaint details horrifying cases. A store owner robbed 3 times, waiting 18 months for nothing. A woman stalked told her interview was 24 months away while her stalker violated restraining orders twice. Denying permits in these neighborhoods isn't just unconstitutional. It's dangerous. It's leaving the most vulnerable citizens disarmed precisely when they need protection the most. But finally, someone decided to fight back. September 30th, 2025. Mark that date. The Department of Justice filed something unprecedented in American history, an affirmative civil rights lawsuit specifically designed to protect gun owners from government abuse. Let me repeat. The federal government is suing a local government for violating the Second Amendment rights of its citizens. This wasn't defense. This was offense. Filed in federal court, the lawsuit names the LA County Sheriff's Department and Sheriff Robert Luna personally. Attorney General Pam Bondi was blunt. The Second Amendment is not a second-class right. Los Angeles County may not like that right, but the Constitution does not allow them to infringe upon it. The DOJ isn't asking politely. They are demanding a permanent injunction, forcing LA County to process permits lawfully, potentially under federal oversight. Where did this sudden aggression come from? Directly from the Trump administration is Second Amendment Enforcement Task Force, created specifically to weaponize federal power for gun rights, not against them. And they've made it clear. Los Angeles is just the beginning. They've set up channels for citizens nationwide to report permit delays over 4 months and are actively investigating other jurisdictions. The message is clear. Defy the Constitution, and the federal government will come after you. But LA County isn't going down without a fight, and their excuses are, well, exactly what you'd expect. Caught red-handed. What did the LA County Sheriff's Department do? Exactly what failing bureaucracies always do. Blame the paperwork and cry about staffing. They disputed the numbers, claimed they are issuing more permits now, conveniently after the DOJ investigation started in March 2025. They blamed inheriting a broken system, transitioning to a new online platform, needing more staff. Here's the problem with all those excuses. Constitutional rights don't wait for administrative convenience. You can't deny a fundamental right because your filing system is outdated or you didn't hire enough people. If you can't provide the service, stop collecting the $1,000 application fees. Their own data proves they only started approving permits in significant numbers after the Fed started watching. It proves federal oversight is the only thing forcing them to comply. This wasn't about resources, it was about resistance. And the economic data proves suppression was always the goal. Forget the public safety excuse. Research proves the permit bureaucracy was designed to suppress gun ownership, especially among those who need self-defense most. Studies show when states ditch may issue for shall issue, online handgun purchases jump 21%. Background checks surge 35%. Who's buying? Not new owners. It's existing law-abiding gun owners finally allowed to carry outside their homes. And here's the smoking gun. This surge is substantially greater in high-crime urban areas than peaceful suburbs. The very people blocked by subjective denials were those living in the most dangerous neighborhoods. The guns purchased? Concealed carry handguns like 9mm and .380s, not home defense shotguns. Proof positive they wanted to exercise their right to carry. Interestingly, when states go fully permitless, there's no significant additional jump in purchases. This confirms the bureaucratic discretion of may issue was the real barrier, not the permit process itself. While the courts and DOJ dismantle these systems state by state, Congress is preparing the final blow, making your concealed carry permit work just like your driver's license, nationwide. Meet House Resolution 38, the Constitutional Concealed Carry Reciprocity Act. Introduced in January 2025, this is the legislative kill shot to state-level permit discrimination. The concept is simple. If you can legally carry concealed in your home state, your permit, or your state's constitutional carry status, must be recognized in every other state that allows concealed carry, just like your driver's license. New York, California, New Jersey, their attempts to block out-of-state carriers would be federally preempted. With Republicans controlling Congress and the White House, H.R. 38 has strong chances of passage. Gun rights groups are celebrating, noting 29 states already have permitless constitutional carry. President Trump himself has promised to sign it, calling it common sense, to ensure your right to self-defense doesn't vanish when you cross a state line. This legislative push, combined with rolling back Biden-era regulations, represents a full-scale assault on gun control. But even national reciprocity begs the fundamental question: why should any law-abiding citizen need government permission to exercise a constitutional right in the first place? The entire permit system is collapsing under its own unconstitutional weight. Bureaucrats nationwide are panicking, realizing the era of permission slips for rights is over. The battleground is shifting faster than ever. Court rulings, DOJ actions, federal legislation. It's a full-blown counter-offensive to restore the Second Amendment. If you want to stay ahead of every legal development, understand what it means for you, and ensure your rights are protected, you need to be subscribed to Second Amendment Sentinel. Smash that subscribe button. Hit the notification bell right now. This is not the time for complacency. Drop a comment below. Tell us which anti-gun state you think will fight back hardest against this federal enforcement. Your voice matters in this fight. Like this video, share it with every gun owner you know. Let the truth spread like wildfire. Until the next Frontline report, stay armed, stay informed, stay free.